She is in need of both temporary and permanent spousal support.
Parties clearly have not been able to afford their lifestyle. Parties have needed dual incomes.
This matter is before the court on the plaintiff's motion for temporary custody, parenting time support, spousal support, payment of bills, and exclusive use. Ms. McDeff. Miss McDeff. I just had Ms. McDeff on a couple of hearings, so she's on my mind still. Ms. Podolsky.
No problem, Your Honor. As we stated in our motion, these parties have two minor children, ages 10 and 6. Parties have been married since 2015. Throughout the marriage, my client has been a stay-at-home parent. She has been diagnosed with psoriatic arthritis that does prevent her from working outside of the home. And therefore, the parties agreed that she would stay at home with the minor children, making defendant the sole breadwinner in this household. As we stated in our motion, and it was admitted to in the answer, the defendant has had no overnights with the minor children since August 6th. That's essentially 3 months now, Your Honor, since he's had overnights with the minor children. We've grave concerns about his mental health. There have been threats of suicide. He's come to the home and caused damage to the home, and it was been a very volatile marriage. In the answer to the motion, the defendant alleges that my client has denied him parenting time. However, again, this has been 3 months where he has not sought overnights with the minor children. He hasn't come to the court to rectify that, file his own case, and it wasn't until my client filed this case and is seeking this order that he has stated that he wants to be a part of their lives. As we've stated in our motion, due to her diagnosis and her inability to work, she is in need of both temporary and permanent spousal support. We outlined in detail in the motion the monthly household bills, including the credit cards that the parties have together. At a minimum, on a temporary basis, my client is in need of support for the mortgage home equity line of payment, the homeowner's insurance and property taxes, her car payment and car insurance, as well as the health insurance and out-of-pocket medical expenses for both herself and the minor children. Again, those expenses were detailed also in the motion and are significant, and he does admit that those out-of-pocket expenses exist. My client, again, being a stay-at-home parent, was not privy to the parties' financial information. She does not know what defendant has in terms of accounts. We are seeking a mutual restraining order against the dissipation of marital assets. And at this time, she has no other place to live with the minor children. She's been residing in the marital home with the minor children since the parties separated. We're asking the court to grant an order of exclusive use as well. So we're seeking the sole legal and physical custody of the minor children. We are looking to the court to set a parenting time schedule for the defendant, an order of child support consistent with the Michigan child support formula, and that temporary order of spousal support, exclusive use of the marital home, and a restraining order against the dissipation of marital assets. Thank you.
Thank you. Ms. Podolsky, when I reviewed the motion, I was struck by the fact that I know you asked for a lot of things, but you never gave me any income for the defendant, so I had no idea to figure how I could calculate that.
Again, we don't know that, Your Honor. My client was not privy to his income information. She relied on him to pay household bills. They were paid during the marriage. As we outlined, there are several of them, and they were all paid until this separation, and now they're only paid sporadically along with no support for the minor children. So we are in need of his income information, and that's why we are requesting at a minimum those essential payments during the pendency of this divorce, and while that financial information can be turned over to us.
Okay, thank you. Ms. Bailey Hobbs?
Thank you, Your Honor. With regard to my client's income, I do believe in the complaint for this case that the plaintiff did outline what she thought to be my client's income. I think she said it was around $60 per hour. That is inclusive of the union benefits. My client receives between $38 and $41 per hour. The rest of it goes toward benefits. So that goes towards the providing for health insurance and whatnot. With regard to other finances, there aren't any. These parties have clearly lived above their means. If you look at the complaint and the motion, it outlines that there are almost $2,500 $2,600 in minimum payments. Actually, it's $2,361 in just minimum monthly payments for credit cards. Parties clearly have not been able to afford their lifestyle. The parties have needed dual incomes. Mr. Wilson denies that they agreed that Miss Wilson would be a stay-at-home mother. That was part of the breakdown of their marriage, was that she refused to work once her psoriatic arthritis got under control with the use of medication. She does have the ability to work outside the home, and she also has her mother living with her who can financially contribute somewhat, at least a little bit. With regard to exclusive use, Mr. Wilson does not have an objection to Ms. Wilson having exclusive use, provided he's able to go to the property if necessary to obtain personal property. He would provide reasonable notice, 48, 72 hours, whatever the court wants. He has not been back to the house since he left in August. He's not been back to the house to vandalize the house or ruin the property. He does not expect that he'll have to go to the house often, but he also left with just the belongings that he was able to take when he left. The reason why he left is that Miss Wilson assaulted him. She is currently dealing with domestic violence charges. That trial is this Thursday on the 31st. So it goes, it's clear that Mr. Wilson has concerns regarding her violence and her tendency to use aggression. His mental health is just fine. It's been even better since the two of them have been separated. With regard to the children, the parties have struggled in communication. Mr. Wilson asked the court to grant a co-parenting application to be used absent an emergency. App close is probably the most reasonable given the financial status. Regarding legal custody, there's no reason why Mr. Wilson should not have joint legal custody. He is an involved father, absent the past 2 months when he was unable to contact the children. He's raised them alongside their mother. He should continue to have decision-making authority jointly with her mother. Parenting time needs to be ordered by this court. Ms. Wilson indicates in her motion she wants the court to grant parenting time as the parties mutually agree. She has not let Mr. Wilson see the children since separation. She also has not let them talk to their father but a handful of times. He's asking the court to enter an order granting him parenting time on alternate weekends from Friday at 6 until Sunday at 6, video, telephone parenting time every Tuesday and Thursday at 7 p.m. via app close. Ms. Wilson does not answer his calls when he calls or texts, so he would ask the court to order her to initiate that call for the parenting time. He asked the court to order the parties share holiday parenting time on an alternating basis, split winter and summer breaks. Regarding support, she's asking that my client pay all the bills. It's impossible. These parties cannot live with the one income. Look at their credit card bills. The parties are now living separately, which means we have more expenses. Mr. Wilson has expenses for rent in $400 per month. He also has his own gas and groceries. He's been providing Miss Wilson $160 per week through the FOC. That's the other child support case that was mentioned in the motion, and that should be and it's found on a search in the courts. He's also been providing Miss Wilson with $320 per week on top of that. So he's been giving her a total of $480 per week, which equals $2,080 per month. I ran some quick calculations, and without a hearing to impute income to mom, that puts us right around where we would be for support, give or take a little bit here or there. We would ask the court to set an evidentiary hearing regarding mom's ability to earn income. He's asking the court to order that he continue paying Miss Wilson that $320 per week on top of the $160 he already pays to the FOC. He has been paying the home equity line of credit, car insurance, and the cell phone bill minus $200 that plaintiff has been contributing. Miss Wilson wants him to pay her car payment, but she doesn't have a license. She can't legally drive. So we have a car payment and car insurance on a vehicle. They can't legally be driven. Mr. Wilson asked the court to require him to, as I said, pay that support, and then on top of that, pay the home equity line of credit in order to keep the house in good standing.
Okay, thank you. Well, what the court's gonna do is the court notes that, as stated, that, he has not had any overnights from, August 6, 2024. So the court is going to continue the status quo and grant to the plaintiff the, temporary custody of the minor, children in this matter. Court will order that the, defendant will have parenting time, standard alternating weekends, midweek, alternating holidays. That alternating midweek will commence on November 6, 2024, and the weekend would start on November 8, 2024 at 6:00 p.m. The court would grant to the plaintiff exclusive use of the marital home, which the defendant is not disputing, and would order that he would pay, I guess there's a home equity or a home mortgage, taxes and insurance, and he's going to continue to pay the car insurance payments. The court would order that he would pay those in the interim as well. That the court would order and permit him to pick up his personal property on the November 8, 2024 date when he picks up the children. Court would order that the parties would communicate through app close, and that there would be a mutual restraining order against dissipation, secreting, or disposing of assets in this matter. Court on the support, the court has a little bit. Ms. Podolsky, is there any problem if he continues to pay the $2,080 per month as he's been paying, as in or have that in lieu of the support, or have that as the support amount?
As child support,
Yes,
in addition to continuing to pay the equity line of credit, taxes and insurance.
correct.
I mean, I have not spoken to my client about that. I can imagine that's not what the child support formula would provide. So we'd be asking that support be calculated pursuant to the formula.
Okay, the court can do that. We'll let you calculate it. You now have his income. They're saying he's making $60 an hour, but that there is a deduction that he makes close to 40 after deduction. Ms. Bailey Hobbs, you can provide documentation to Ms. Podolsky as to what the deductions are. And then any insurance likewise that would be attributable to the children would be deducted. The court would then order that the support would be the amount of that the court would impute to the plaintiff the minimum wage 40 hours a week for purposes of calculation. And the court is going to reserve on spousal support in this matter in view of the fact that he is paying those particular bills and expenses. And the court doesn't have all of the information I need to calculate that in any event. So Ms. Podolsky, you can prepare that order and submit under 7 days.
Thank you.
Thank you.
Your Honor, may I ask for clarification on one thing?
Okay,
You indicated that status quo regarding custody should continue with plaintiff having custody. Are you referencing legal or physical custody or both?
both.
One other question, Your Honor. Did you say a date when defendant could get his personal belongings, or did you?
Yes, I did. I said on November 8, 2024 at 6:00 when they have exchange of the children.
Perfect. Thank you.
Okay, thank you.